My name is Simone Weatherly, and I am 49 years old. I spent 22 years as a legal secretary at a mid-sized firm in Cincinnati, which means I have spent 22 years watching other people's disputes get resolved on paper while my own went unresolved in silence. I know how a contract works. I know what an addendum is. I know the difference between a verbal agreement and an enforceable one. I know that the sentence the courts will care about is the one that was written down, not the one that was said over dinner with wine in the glasses and goodwill in the room. I knew all of this when my husband's family asked us to move into the house. I said yes anyway because I loved my husband, and because the arrangement made financial sense on paper, and because his mother was 71 and needed someone nearby, and because I believed, in the way that sensible women sometimes believe unreasonable things, that knowing how something could go wrong was the same as preventing it. It is not the same thing. Not even close. What I should have done was draft the agreement myself, in writing, with signatures, before we sold our house and moved our furniture and gave up the life we had built in the 8 years since the children left. What I did instead was trust the warmth of the room, which is the oldest mistake in the book, and I have typed enough legal documents to know it is the oldest mistake in the book, and I made it anyway. What saved me was not my legal knowledge. What saved me was a habit I had developed over 22 years of watching other people fail to have the documents they needed. I kept copies of everything. Every email, every text, every note I jotted to myself after a verbal conversation, dated and saved in a folder on my laptop that I had been building, without a specific plan, for 3 years. That folder became the only thing standing between me and the version of events my mother-in-law preferred. Welcome to Calm Drama Stories. My name is Simone, and this is where women who have spent their careers understanding how things go wrong on paper discover that the lesson applies to their own lives too, sometimes later than it should, always when it matters most. If you are new here, subscribe and drop your city in the comments. Stay with me. This story starts with a family dinner and a warm room and a verbal agreement, and it ends in a conference room where I was the only person at the table who had read all the documents. Let me tell you about the house. The house is a 4-bedroom colonial in Anderson Township, a suburb of Cincinnati, that my father-in-law Raymond built the equity in over 40 years of careful living. Raymond died 6 years ago, leaving the house to his wife, Eleanor, my mother-in-law, and to their 3 children in equal shares, my husband Dale, and his siblings Carla and Mitchell. Eleanor had right of occupancy for her lifetime. When she died, the house would be divided equally among the 3 children. This was in the will, clearly drafted, no ambiguity. I had read it myself because Dale had asked me to look it over, and I was the one in the family who read legal documents for a living. The problem was not the will. The problem was what happened after the will, when Eleanor was 71 and alone in a 4-bedroom house and increasingly unable to manage it by herself, and when Dale and I were 51 and 45 at the time, with a paid-off mortgage on a house we loved in Hyde Park, and when Carla lived 40 minutes away and Mitchell lived in Denver, and neither of them had any intention of being the ones who moved. The conversation started at Christmas. Eleanor said, over dinner, that the house felt too big. She said she was worried about the maintenance. She said she would feel better with family nearby. She looked at Dale when she said it, the way mothers look at the child they have always relied on when they want something without asking directly. Dale looked at me. I looked at my wine glass. The conversation evolved over several months. By March it had become a proposal. Dale and I would sell our house, move into the colonial with Eleanor, take the master bedroom and use the other 2 bedrooms as we liked. In exchange, we would help Eleanor with the house, the management, the maintenance, the daily presence of family. When Eleanor passed, our portion of the estate would reflect our contribution. More than a third. Possibly more than half, depending on how the siblings negotiated when the time came. Depending on how the siblings negotiated. I heard those words and I wrote them down that same evening, in the Notes app on my phone. March 14th. Over dinner at Eleanor's. Dale and I would receive a larger share of the estate, exact amount to be negotiated, in recognition of our contribution to her care and the maintenance of the property. I wrote it down because I had spent 22 years watching the phrase to be negotiated become the site of every dispute I had ever filed paperwork for. To be negotiated is not an agreement. It is the location of a future argument. I told Dale this. He said, "Mom's not going to argue with us. She's grateful." I said, "I know she's grateful right now. I'm talking about what happens in 5 years or 10, when Carla and Mitchell decide that grateful doesn't mean a bigger percentage of the house." He said, "This is family, Simone." I had heard that sentence before. Not about this situation. About every situation in which someone wanted me to behave as though a document was unnecessary. I had typed enough contracts to know that the need for a document is not a sign of distrust. It is a sign that both parties understand what they are agreeing to and intend to be bound by it. Documents protect the relationship. They do not threaten it. But Dale was not a legal secretary. He was a man who loved his mother and trusted his family and found the suggestion that we needed a written agreement to be a slight against people who did not deserve it. I did not push. I agreed to the move. I kept my notes. We sold our Hyde Park house in June. We moved into the Colonial in July. I want to tell you what that felt like, because I think it is important to understand what was given up before I tell you what was fought for. The Hyde Park house had been ours for 9 years. Dale and I had repainted it twice, remodeled the kitchen, built a deck that we sat on every summer evening with wine and the specific satisfaction of people who have made something they like out of the space they were given. Our children had been in and out of it every holiday. I had a home office that I had arranged exactly the way I wanted it, with my reference materials in the order I preferred, and a window that looked into the garden that I had planted over 9 years into something that looked like it had always been there. I packed all of it into boxes. The garden stayed. We sold the deck with the house. The Colonial was a good house. I want to say that clearly. It was well built, well maintained, in a good neighborhood, and Eleanor kept it with the care of a woman who understood that a house was an asset and treated it accordingly. But it was not my house. My things were in it, but the arrangement of everything else, the furniture Raymond had bought, the photographs on the walls, the way the kitchen was organized, was Eleanor's, and I was a guest in the logic of it in a way that never fully resolved, no matter how long we lived there. Eleanor was not difficult to live with. She was orderly, independent, appreciative. She thanked us for things. She did not interfere with our routines or make demands that were unreasonable. For the first year, the arrangement was, if not what I had imagined for my 50s, workable. In the second year, Carla started visiting more. Carla Weatherly is Dale's older sister by 4 years. She is a dental hygienist in Mason, Ohio, 40 minutes from Anderson Township, who has strong opinions about the right way to do most things in a warm, efficient manner that can be difficult to distinguish from controlling until you have been on the wrong side of it. In the first year, Carla visited once a month. She would come for Sunday dinner, stay for 3 or 4 hours, help Eleanor with whatever small tasks had accumulated, and leave. She was pleasant to me. We were not close, but we were functional. In the second year, the visits became more frequent and the focus of the visits shifted. She began arriving with opinions about the house. The gutters should be cleaned differently. The garden beds Eleanor had asked me to tend were being done wrong. She had a specific method. The master bedroom that Dale and I occupied had been Raymond's study before the renovation, and she had memories of that room, and sometimes she stood in the doorway and said things about those memories that were not quite accusations but were not quite not accusations either. She also began having longer conversations with Eleanor about the house. Not about our arrangement, about the house itself, its history, its future, what Raymond would have wanted. I was not included in these conversations. I learned about them afterward, from Eleanor, who would mention them in passing without seeming to understand that she was telling me something significant. In month 19, Eleanor mentioned at dinner that Carla thought it might make more sense for the estate to be divided equally when the time came. Equal thirds. The traditional arrangement. Dale said, "We talked about this, Mom. Simone and I get a larger share because we're here." Eleanor said, Of course, of course. I just want everyone to feel it's fair. I said nothing. I went upstairs afterward and added to my notes. Month 19. Dinner. Eleanor mentioned Carla's position on equal division. Dale restated original understanding. Eleanor non-committal. I had been adding to my notes every time something relevant was said. Every conversation about the estate, every mention of Carla's position, every comment Eleanor made about the arrangement and whether it was working. I dated everything. I noted who was present. I noted the exact words when I could. I was not building a case. I was doing what I had done for 22 years. Keeping the record because the record was all you had when the room started remembering things differently. Month 23. Eleanor's doctor had a conversation with her about her long-term care needs. She was managing well, but the doctor wanted her to think ahead, about what level of support she might need in the coming years, about whether her living situation would continue to be appropriate. Standard geriatric planning. Eleanor called Carla after the appointment. I do not know exactly what was said, but the call was 42 minutes long, which I know because Eleanor mentioned it, and Carla arrived the following Saturday with Mitchell on video call on her tablet, propped up on the kitchen table during a family meeting that I had not been told was a family meeting until I walked downstairs and found it in progress. I sat down. I listened. Carla said, We've been thinking about Mom's long-term situation. We want to make sure everyone is on the same page about what happens as her needs change. She looked at me when she said everyone. Not at Dale. At me. Mitchell, on the tablet, said, We think it's important that the estate arrangement is formalized. So there's no confusion later. I said, I agree completely. What did you have in mind? A pause. I think they had expected resistance. I had not given them resistance. I had agreed with the premise immediately because the premise was correct and I had been saying it for 2 years. Carla said, We think the estate should be divided equally. Thirds. As Dad originally intended. I said, Raymond's will divides the estate equally because it was written before Dale and I moved in and made a different arrangement. The arrangement we made when we moved in modified the expected distribution. Mitchell said, What arrangement? There's no document. I looked at him on the tablet screen. I said, There's no signed agreement, no. There is, however, a 2-year record of conversations about the arrangement, including the original dinner in March where the terms were discussed, multiple subsequent conversations in which Eleanor confirmed the understanding, and email correspondence in which the contribution to the household was acknowledged. Carla said, Email correspondence? I said, Yes. I had 3 emails. One from Eleanor to Dale, copied to me, from the first month, saying how much she appreciated having us there and that she wanted to make sure we knew the house would reflect our sacrifice. One from Carla herself, 8 months in, asking me to coordinate the fall maintenance schedule because, as she had put it, you're the one running the house now. And one from Mitchell, a year ago, asking if Dale and I planned to stay long-term because it affected how he was thinking about his own financial planning. 3 emails. None of them an explicit contract. All of them evidence of how the arrangement had been understood by the people in it. I said, I'm happy to share what I have. And I think formalizing the arrangement is a good idea. I think we should have done it 2 years ago. I'd like to do it now. The kitchen was very quiet. I want to pause here and tell you about the moment I almost did not say any of that. I had been sitting at the kitchen table for 4 minutes before I spoke. In those 4 minutes, I had watched my mother-in-law not quite look at me, and my sister-in-law look at me with a specific expression of someone who has prepared for an argument, and my brother-in-law's face on a tablet screen doing something that was not quite neutral. And I had felt very clearly the shape of what they expected from me. They expected me to be reasonable. Not in the genuine sense, in the managed sense. They expected me to hear the proposal, feel the social weight of it, understand that 3 against 2 was the arithmetic they were presenting, and find a way to accept it that allowed everyone to feel the outcome was fair. This is what reasonable has meant for most of my life, in rooms where the people with more leverage want something from me. Be reasonable means absorb the cost. Find a way to be gracious about a bad deal. Make it easy for everyone, which in practice means make it easy for everyone who isn't you. I had been reasonable for 49 years. I had typed thousands of contracts and not once drafted one for myself. I had known at the kitchen table in March 2 years ago that the phrase to be negotiated was a problem, and I had not solved the problem because solving it would have required me to be unreasonable in a warm room with wine in the glasses. I was in a different kind of room now, and I had 3 emails. I said what I said. Dale and I retained an attorney that week. Her name was Constance Park, and she had been practicing estate and family property law in Cincinnati for 30 years, and when I laid out the situation she read my notes, all 23 months of them, printed and organized by date, without interrupting once. When she finished, she said, "You've been keeping this since before the move?" I said, "Since March of the year we moved. March 14th. The first dinner where the arrangement was discussed." She said, "In your professional capacity, you understand what this represents." I said, "Evidence of an oral agreement and the parties' understanding of its terms." She said, "More than that. You have contemporaneous documentation, notes made at or near the time of the events they describe. That is stronger than memory in any proceeding, and significantly stronger than memory that has had 2 years to be revised by interested parties." I said, "What can we do with it?" She said, "We can establish on the basis of the emails and the notes that an agreement existed. Not a written contract, that would have been better, but an agreement that was acted upon, understood by the parties, and relied upon by you and Dale to your detriment." To your detriment. The sale of the Hyde Park house. The garden I had left behind. The 9 years of a home that was mine, given up in reliance on an understanding that Carla was now trying to renegotiate from a kitchen table. I said, "What does that get us?" Constance said, "A claim in equity. Unjust enrichment or promissory estoppel, you relied on a promise to your detriment, and allowing the promise to be revoked without compensation would be unjust. It won't give you a signed contract, but it gives you standing to enforce the arrangement you actually made." I said, "And Eleanor?" Constance was quiet for a moment. "The complication," she said carefully, "is that Eleanor is both a witness to the original agreement and a party whose wishes about her own estate matter legally. If she maintains that the original arrangement was not what you understood it to be, that complicates your position." I said, "She was at every dinner. She was on the email that said she wanted the house to reflect our sacrifice." Constance said, "I know. Which is why we lead with the email. You let her words do the work before anyone asks her to remember them differently." The meeting was at Constance's office. Not a courtroom, not a mediation center, Constance's conference room, which had good light and a long table and no particular drama except the kind that people bring in with them. Dale, me, Carla, Mitchell by phone this time, and Eleanor. No spouses. Constance on our side of the table. Carla and Mitchell had retained their own attorney, a man named Greg Haas who I recognized from the firm where I worked. He handled property disputes, competent, thorough, not someone who made mistakes. Eleanor sat at the end of the table. I had not known what Eleanor would do. This was the thing I had not been able to plan for, Eleanor's position. She had been non-committal at the dinner 2 months ago. She had said of course, in the way she said things she did not want to engage with directly, and then she had had 42-minute phone calls with Carla and hosted a family meeting in her kitchen without telling me. I loved Eleanor. I want to say that clearly because it is true and it matters. I had moved into her house because I loved Dale and because she needed someone and because I was the kind of person who showed up when someone needed something, the same way I had always been. I had planted her garden beds and scheduled her maintenance and driven her to appointments and sat with her on the back porch on summer evenings when the light was good. I had done all of it willingly, without scorekeeping, because that was the arrangement and I had agreed to it. I was not angry at Eleanor. I was sitting across a conference table from the consequences of having agreed to something that had not been written down, and the consequences had a shape that included Eleanor's children, and Eleanor's children had been working on Eleanor for 2 months, and I did not know what version of the arrangement Eleanor was going to describe when someone asked her. Constance opened with the emails. She did not open with my notes. She started with the documents that had no authorship problem, the ones in which the parties themselves had described the arrangement in their own words. Eleanor's email first. Constance read it aloud. I want to make sure we knew the house would reflect our sacrifice. Eleanor's expression did not change. She was looking at the table. Carla's email next. You're the one running the house now. Carla started to say something. Greg Haas put a hand briefly on her arm. Mitchell's email last. It affects how he was thinking about his own financial planning, meaning the fact of our long-term presence was a fact he was incorporating into his own calculations. He had understood the arrangement well enough to plan around it. Constance set the emails down. She said, I want to be clear about what these documents establish. They establish that the parties to this arrangement, including Mrs. Eleanor Weatherly and all 3 of her children, understood that Dale and Simone's presence in the house represented a contribution that would be recognized in the estate distribution. This is not a disputed fact based on these emails. It is written in the words of the people who are now suggesting it was never agreed to. Greg Haas said, 3 emails over 2 years is not a contract. Constance said, no. It's evidence of an agreement that was acted upon. Over 2 years, my clients sold their home, relocated, and provided daily support to Mrs. Weatherly in reliance on that agreement. The doctrine of promissory estoppel holds that a promise which the promisor should reasonably expect to induce action, and which does induce such action, is binding if injustice can only be avoided by enforcement. She let that sit. Then she said, Mrs. Weatherly, I'd like to ask you directly, because your recollection is central to this. When Dale and Simone agreed to move into your home, what was your understanding of how the estate would be distributed when the time came? The room went very quiet. Eleanor looked up. She looked at Carla. She looked at Mitchell on the phone. She looked at Dale. She looked at me. I did not look away. Not with challenge. With the steady attention I had been giving her for 2 years, the same attention I gave the garden and the maintenance schedule and the Sunday dinners. I had been in her house with the same face the whole time, and she knew that face, and I wanted her to remember that the face had been there every day and Carla's face had been there twice a month. Eleanor said, slowly, we agreed that Dale and Simone would be compensated. That they would get more than 1/3. I said that. Carla said, Mom. Eleanor said, I said it, Carla. I remember saying it. And I meant it when I said it. I want to tell you what happened in the rest of that meeting, but first I want to tell you what happened in my chest when Eleanor said those words. I have been in enough legal proceedings, adjacent to enough of them, to understand that the moment a key witness says the right thing is not always a triumphant moment. It is often a quiet one, smaller than you expected, because the thing you needed was not a dramatic reversal. It was just accuracy. You needed the record to be accurate, and when the record became accurate you felt not triumph but something more like the sensation of a weight being set down that you had been carrying for 2 years and had almost forgotten was weight. Eleanor said I meant it when I said it, and I felt my shoulders do something they had not done in 23 months. They settled. I had not built the notes to win. I had built them to have the accurate version available when the inaccurate one appeared. The inaccurate one had appeared. And the person whose words mattered most had chosen accuracy over her children's preferred version of events. That is what 2 years of being present looks like, when it comes to the moment. The negotiation took 4 more weeks. I will not walk you through every session because the sessions were detailed and procedural and the details matter less than the outcome. The outcome was this. An agreement was drafted, a real one, signed, witnessed, filed with the estate. Dale and I would receive 45% of the estate value upon Eleanor's passing. Carla and Mitchell would divide the remaining 55%, which was still collectively more than the original equal distribution would have given them individually. Eleanor's contribution was a notarized statement describing the original arrangement as she had understood and intended it, which was incorporated into the agreement. My notes were submitted as part of the records supporting the agreement. 23 months of dated entries, every conversation logged, every relevant email cross-referenced. Constance called them the most thorough contemporaneous record she had seen outside of a litigation context. I said, "I'm a legal secretary. We document things." She said, "More people should." I drove home from the final signing with Dale, and we sat in Eleanor's driveway for a moment before we went inside. Dale said, "I should have let you draft the agreement 3 years ago." I said, "Yes." He said, "I'm sorry." I said, "I know. And then, next time you tell me something is family and doesn't need paper, I'm going to draft the paper anyway." He said, "Good." We went inside. Eleanor had made dinner. We ate at the kitchen table where the family meeting had happened, and Eleanor talked about her garden and the fall maintenance and whether we should repaint the shutters, which had been a conversation we had been having for a year. I said, "Let's do the east side first. The sun hits it harder." She agreed. We made a plan. I wrote it down the way I wrote everything down, and dated it the way I dated everything. Not because it was legal. Because it was real, and real things deserve a record. Here is what I want to say to you, because I think there are a lot of you in warm rooms right now with wine in the glasses and a verbal understanding and a family that would be offended by the suggestion of paper. I understand the room. I have been in the room. I have spent 22 years watching what happens when people leave the room without the paper, and I left my own room without the paper because I was in it and the wine was good and everyone was warm and it felt like the right thing to do was trust the warmth. Trust the warmth. And also write it down. These are not opposing instincts. The paper does not say you don't trust the people in the room. The paper says, we trust each other enough to describe clearly what we are agreeing to, and we are confident enough in the agreement to make it permanent, and we like each other enough to protect the relationship from the arguments that ambiguity produces later. That is what a contract is. Not a sign of distrust. A sign that the agreement is worth keeping. My notes were not a contract. They were the second best thing, a record of what was said and when, that could stand in for the contract we should have drafted in March, that could anchor Eleanor's memory against Carla's preferred version of events, that could give Constance what she needed to make the claim. They worked. They worked because I had been building them from the beginning, not from the moment the problem appeared. Start building from the beginning. Not because you expect a problem, because a record built before the problem is evidence, and a record built after the problem is a grievance, and only one of those is useful in a conference room. Eleanor is 73 now. She is well. She is in the garden on good days, and on the back porch on the others, and she calls me into the kitchen sometimes when she is making something she wants me to learn, a recipe her mother made, a technique for the specific kind of pastry that I had never understood before. I learn it because she is teaching it, and because the teaching is a kind of care. I have filed our agreement in the home office. I eventually made my own in the 4th bedroom, which I repainted myself on a September weekend and arranged exactly the way I want it. The reference materials are in my preferred order. The window looks out over the garden I have been tending for 2 years, and that is starting, slowly, to look like it was meant to be here. I am 51 now. I am not in the house I chose at 45. I am in the house that needed me, with the person I love, with the garden I planted, with the agreement on file and the notes in the folder and the record as accurate as I know how to make it. It is not what I imagined for my 50s. It is what I built, which is different, and in some ways better because I built it with my eyes open. Dale and I sit on the back porch on summer evenings when the light is good. We do not have the deck we built in Hyde Park. We have a porch that was here before us and will be here after. We sit on it and drink wine and talk about the garden and the shutters and the fall maintenance, and I think about the fact that everything real I have is either documented or sitting across from me, and that is enough. That is everything, actually. That is my story. 22 years of typing other people's contracts. One verbal agreement I should have put on paper. 3 emails. 23 months of dated notes. A conference room in Cincinnati and an attorney named Constance and a mother-in-law who chose accuracy over her children's preferred version of events. And an agreement now signed and witnessed and filed that says clearly what was agreed and by whom and what it means. If you are in a warm room right now with a verbal understanding and people you trust, I am not asking you to stop trusting them. I am asking you to also write it down, for their sake as much as yours. Because the argument does not happen between you and the people in the room. It happens between the memory of what was said and the version that someone else constructs later, and the only thing that can defend you against that version is a contemporaneous record that was built when everyone still agreed. Write it down tonight. Date it. Send yourself an email if nothing else. Your own words, your own account, the date in the subject line. It costs you nothing. It protects everything. Drop your city in the comments. And if you know someone who is in the middle of a verbal arrangement with family right now, share this with them. Not as a warning, as a tool. Subscribe if you are new here. I will see you in the next one. And to Eleanor, thank you for telling the truth in that conference room. I knew you would. I just needed to make sure we had what we needed in case you didn't. I want to take you back to the 9 years in the Hyde Park house, because you need to understand what was given before you can understand what was at stake. Dale and I moved into the Hyde Park house in 2013, the year our youngest went to college. We had spent 18 years in a larger house that was organized around children. The rooms, the noise, the particular chaos of a house with people in it who have not yet learned to manage themselves. When the children left, we were 2 people in 4 bedrooms, and for a year we circled the space like it was unfamiliar territory, and then we sold it and found the Hyde Park house, and it was like exhaling. 1,200 square feet. 2 bedrooms, one of which became my office and one of which was ours. A kitchen that was small enough to feel immediate, everything within reach, nothing wasted. The garden, which I had planted from scratch on a budget of $40 a season and which had, by year 5, grown into something that made the neighbors stop on the sidewalk. I had never had a garden before Hyde Park. I had not known I wanted one. I had planted the first bed on a May weekend on an impulse, crouching over the soil with my hands dirty for the first time in my adult life, and something had settled in me that had been unsettled for a long time, and I had not known it until it settled. 9 years. I watched that garden through 9 seasons. I learned what it wanted. I learned the difference between the plants that needed my attention and the ones that performed better when I left them alone. I learned that the garden was its own record, that what you planted in May was still visible in September, that the choices you made were legible in the soil and the growth and the shape of things. When we sold the house, I could not take the garden. You cannot take a garden. You can take cuttings, seeds, the knowledge of what grew and how, but the garden itself belongs to the ground it grew in. I took 3 cuttings. I planted one of them, the following spring, in the Colonial's back bed. It is growing. It looks like something that arrived from somewhere else, which it did, and which is visible if you know what you are looking at. I know what I am looking at. That is the whole of it, in gardening and in legal documentation and in everything else. You know what you are looking at, or you learn, and then you can tend it correctly. I want to tell you about Dale, because he matters to this story in a way that is easy to underestimate. Dale Weatherly is a man who trusts the room. He has always trusted the room. He grew up in a family where the room was trustworthy, where Raymond kept his word and Eleanor meant what she said, and Carla was annoying but not dishonest, and Mitchell lived far away and was therefore mostly harmless. He had not had occasion to discover that the room could want different things depending on how much money was in it. I had typed enough contracts to know that money changes rooms. Not always. Not immediately. But when the amounts become significant and the stakes become real, the room that was warm in January sometimes becomes a different room by March. I tried to tell Dale this before we moved. He heard me. He is not a man who dismisses what I say. he takes it in, considers it, and then trusts the room anyway. Not out of stubbornness. Out of genuine belief that the people he loves will behave the way people who love each other should behave. I share this belief. I just also know it requires paper. When Carla and Mitchell convened the kitchen table meeting, Dale was blindsided. He is the kind of person who is blindsided by things that can be predicted because he has chosen not to predict them, which is a quality I love about him, and also one that requires compensation from the person who is paying attention. I am the person who is paying attention. I have always been the person who is paying attention. 22 years of legal work trains you for that, but honestly, I think I was already that person before the job. The job just gave me language and protocol. When I told Dale after the kitchen table meeting that I had notes, 23 months of them, dated, detailed, he looked at me with an expression I recognized. It was the same expression he had given me in March, before the move, when I had said to be negotiated was the location of a future argument. A mixture of relief and something adjacent to chagrin. He said, "You've been doing this the whole time?" I said, "I've been doing this my whole career. I just kept doing it at home." He said, "Does Constance think it helps?" I said, "Constance said it was the most thorough contemporaneous record she'd seen outside of a litigation context." He was quiet for a moment. Then, "I should have let you draft the agreement." I said, "Yes." He said, "You knew." I said, "I knew the risk. I didn't know if it would materialize. I kept notes in case it did." He looked at me for a long time. Then he said something that I have thought about many times since. He said, "I married someone who knows how things work, and I kept asking her to pretend she didn't because it made me more comfortable." I said, "Yes." He said, "That's not a compliment to me." I said, "No. But it's fixable. It is a very common mistake, and it is fixable." He said, "How?" I said, "You stop asking me to pretend. And I stop agreeing to pretend." We shook on it, which sounds formal, and was. I want to tell you about Carla, because in stories like this one the antagonist is sometimes flattened into a simple version of herself, and I do not think Carla is a simple version of anything. Carla loved her father. This is the beginning of everything. Raymond had built the house with his hands in a meaningful sense, not literally constructed it, but chosen it, paid for it, maintained it for 40 years with the specific devotion of a man who understands that a house is not just an asset but the physical form of everything he was trying to provide. When Raymond died, Carla inherited not just a legal stake in the property but a particular kind of grief that lives in rooms and finishes, and the specific way the light comes through a window at a time of year when the person who chose the window is no longer there to see it. She did not want Dale and me to have 45% of the house because she was greedy. She wanted it because she was afraid. She was afraid that the house her father built would be diminished by the redistribution, that something of Raymond would go with a percentage that would not go to her. I understood this. I understood it from the inside, from the place where you know what it is to lose a garden you planted and feel the loss as something more than property. The house was Carla's garden. The conversation we were having in Constance's conference room was, underneath all its legal language, a conversation about whether grief is transferable, whether the weight of love for a lost person can be converted into a larger share of what they left behind. It cannot. Not by document, not by negotiation, not by kitchen table meetings or attorney conferences. The percentage does not fix the grief. I knew this. I did not say it in the conference room because it was not the relevant argument, but I knew it. What I did say, through Constance, through the emails, through 23 months of dated notes, was, what was agreed is what was agreed, and grief does not revise it. The arrangement that Dale and I made was made in good faith and acted upon to our real, measurable detriment, and the law has language for that, and I know the language because I have typed it for 22 years. Carla left the final signing without speaking to me directly. She signed the agreement. She and Mitchell both did, because Greg Haas had told them what Constance's claim would look like if they refused, and they were practical people, but she signed without looking at me. I did not take this personally, not because I am without feelings about it, because I understood that she was signing something that cost her something real, and that the cost was not just the percentage but the loss of the version of events in which her grief was the deciding factor. It was not the deciding factor. The documents were the deciding factor. And she had to sit with that, and it was not comfortable, and I did not need her to be comfortable with me on the day she signed. We have, in the months since, moved toward something that is not warmth but is civil. She visited last month. She brought a casserole. She sat with Eleanor on the back porch. She did not come into my office. That is fine. The office is mine. I want to tell you about the notes. Not what was in them. I have described the content. I want to tell you how I made them because I think the how is the part that is actually useful. Every time something significant was said, about the arrangement, about the estate, about the family's understanding of what Dale and I were doing there, I made a note as soon as I could. Not always immediately. Sometimes I was in the middle of a dinner and I could not excuse myself to type on my phone without changing the room. In those cases, I made the note within 2 hours. I have a rule in my professional life. Notes older than 4 hours from the event are reconstructions, not records. I applied the same rule at home. I recorded who was present, what was said, as close to verbatim as I could manage, the date and time, any relevant context, the mood of the conversation, what had precipitated it, what came after. I saved every email by forwarding it to a personal account I had created specifically for this purpose. I photographed relevant texts and added them to a folder on my laptop. I cross-referenced by date, the way I cross-referenced everything in my professional files, so that if someone wanted to know what had been said about the estate in any given month, I could produce it in under 2 minutes. I did not share the notes with Dale. Not because I was hiding them, because I was not certain they would be necessary, and showing Dale a folder of notes about his family would have felt like a declaration of war that I was not yet prepared to make. I was preparing for a war I hoped would not happen. The preparation required discretion. When the kitchen table meeting happened and I told Dale about the notes, his reaction was the one I described, relief and chagrin in equal measure. He asked to read them. I let him. He read them without speaking. When he finished, he said, "You remembered all of this?" I said, "I didn't remember it. I wrote it down." He said, "What's the difference?" I said, "Memory can be revised. A note you wrote 2 years ago cannot." He understood. He is a man who, once he understands something, understands it completely. He called Constance the next morning. The notes were the foundation. Without them, we had 3 emails and Dale's word against Carla's. With them, we had a record that was 3 months older than the problem, built by someone with no motive to distort it, in the specific form that legal proceedings find most credible. They worked because I had started them before I knew I would need them. That is the only way they could have worked. A record started on the day of the kitchen table meeting would have been a grievance. A record started 2 years before the kitchen table meeting was evidence. There is a lesson in that timing. I've been trying to find the right way to say it, and the best I have arrived at is this. The time to start keeping the record is always earlier than you think, and the reason is that the problem, when it arrives faster than you expect, and by the time you see it clearly enough to begin documenting it, you are already behind. Start before you need to. Date everything. Do not throw it away. The garden is in its 2nd year. The cutting I brought from Hyde Park has established itself. I know this because it has stopped looking like a transplant. The shock period is over, the roots have found the soil, the growth this season is confident in a way that growth is when it has stopped being a stranger to the ground. There are 3 new beds that I added last spring. One along the east fence, one under the kitchen window, one in the corner Eleanor had been meaning to do something with for 10 years. I planted them with things that would grow slowly and last, perennials, shrubs, the kind of garden that rewards patience and planning rather than annual replanting. Eleanor comes out to look at it sometimes, in the early morning when the light is still low and everything is damp and the garden smells like the best version of itself. She stands at the edge of the patio and looks the way people look at things they are grateful for, with that quality of attention that is almost prayer. She said last week, "Your husband's father would have liked this." I said, "Tell me about what he would have liked." She told me. She told me about Raymond's preferences for the yard, the things he had tried and given up, the tree he had planted 30 years ago that was now too large but which she could not bring herself to take down. She talked for 20 minutes. I listened the whole way. I did not make notes. Some things are for memory, not record. This was one of them. But I remembered it. I will keep remembering it. It is the other kind of record, the one you carry in your body, in your chest, in the part of you that knows what you are looking at and can tend it correctly. The house has a file and a folder and an agreement signed by 6 people. It also has a garden in its 2nd year and an early morning woman standing at the edge of the patio and a cutting that has stopped being a stranger to the ground. Both are real. Both are mine. I want to tell you about the week before the conference room, because it was the week I understood what the notes had actually been for all along. I had known, intellectually, that I was keeping the notes as a hedge, protection in case the arrangement was disputed. I am a legal secretary. I understand hedges. I understand that you prepare for the argument you hope not to have, the way you keep an umbrella in your car not because you plan to get caught in the rain but because the rain does not announce itself. What I understood in the week before the conference room was different. It was not just that the notes would be useful. It was that without them, the version of events that Carla and Mitchell preferred would have had nothing to compete against except my word and Dale's memory. My word and Dale's memory. Against Carla, who was the primary caregiver for the decade before Dale and I arrived, in the family's accounting. Against Mitchell, who was in Denver and had strong feelings from a distance. Against the implicit logic that the original will equal thirds was the natural state of things and that any modification required proof. The burden of proof was on us. The notes were the proof. My mother does not often say things that make me feel better, because she is not primarily interested in making me feel better. She is primarily interested in accuracy. But in this case the accurate version was also the better version, and I held on to it. The 11 years were not the wrong decision. They produced what they produced. I kept the records. The records were retrievable. The money followed the records. What I do next is mine, and mine from the beginning. Dana called me 3 months after the conference room, not about the case. It was resolved. The papers were signed. Phil had processed the management fee restoration. She called about something else. She said, "I want to refer a client to you." I said, "What kind of client?" She said, "A chef. 14 years in a partnership situation. That sounds familiar." She's starting to see the pattern and she needs someone to talk to who has been on the other side of it. I said, "What do you mean, talk to?" She said, "Not legal advice. You're not an attorney. Just your experience. How you recognized it. What you did. What the notebook is." I said, "You want me to tell her my story?" She said, "I think it would help." I talked to the chef. Her name was Marguerite. She had 14 years and no notebook yet, but a very clear sense of what was happening in her partnership and a specific frustration at not knowing what to do with the clarity. I said, "Start the notebook tonight." "Not next week. Tonight." She said, "What do I write?" I said, "What happened today? Who made what decision? Whether it was a decision that required both of you. If you're not sure, read the agreement and check." She said, "And then what?" I said, "Then you come back to it in a month and see what the month looks like in writing. You'll know what to do next." She did. She called me 6 weeks later. She said, "I see it now. It's very clear now." I said, "I know." She said, "What do I do?" I said, "Call Dana." She called Dana. The situation is ongoing. I do not know how it ends. I know that she has the notebook and the agreement and the clarity, and those are the tools, and the tools are what the outcome depends on. I told her, the records do not protect you from what is happening. They make the truth retrievable when you need to retrieve it. Keep going. She is keeping going. Here is the last thing I want to say. I have spent 34 years in professional kitchens. In that time I have cooked for tens of thousands of people who will never know my name, who will remember the dish and not who made it, which is the correct order of things in my profession. The cook is the vehicle. The food is the thing. You do not make food so that people will know you made it. You make food because you understand something about the combination of ingredients and technique and timing that produces, when everything works, the specific experience of a person tasting something and feeling, for a moment, exactly right. That is what I have given 34 years to. Not recognition, not credit, the work itself, and what the work produces in the person eating it. The partnership dispute was not about recognition either, at its core. It was about $214,000 that was not Marcus's to take, and about a business that was being conducted as though one partner had more authority than the agreement granted, and about a woman who had the documentation to say so when the time came. Those are practical things, important and practical and worth pursuing, and I pursued them, and I am glad I did. But what I am most glad of is the notebook. Not because of what it produced in the conference room, though I am glad of that too. Because the notebook is what kept me honest with myself for 11 years. Every entry I made was a reckoning with what was actually happening, as opposed to what I wished were happening or what I was telling myself so that I could keep going. The notebook did not let me hide from the truth of the partnership. It made the truth legible, day by day, entry by entry, until the truth was so legible that I could not look away from it, and when I stopped looking away the rest followed. Keep the notebook. Not for the conference room. For yourself. For the clarity that accumulates when you write down what is real and date it and do not throw it away. The clarity is the thing. Everything else follows from the clarity. I want to tell you about the dish. Not the winter squash dish. I have told you about that. I want to tell you about the first dish I ever made that I knew was mine. Not a version of someone else's recipe, not an adaptation, not an interpretation of a classical technique applied to a new ingredient. A dish that came entirely from my own thinking, with no template, that solved a problem I had been carrying in my head for months without knowing I was carrying it. I was 26. I had been on the line for 3 years. I was working for a chef named Teresa, who was the first woman who had ever run a kitchen I worked in, and who was the first person in my professional life who treated my opinion about food as information rather than noise. The dish was a preparation of bitter greens with a warm, acidic dressing that I had been working on in my head while doing prep, the specific mental activity of a cook who is doing something with her hands while her brain is solving a different problem. I had been thinking about the relationship between bitter and acid and how most preparations I had eaten tried to suppress the bitterness rather than balance it, and I thought the balance was possible, and I had been thinking through the ratios while cutting herbs for 2 weeks. I made it on a Sunday, on my day off, in my apartment, with second-hand equipment and grocery store greens that were not the quality I would have wanted but were available. I made it 6 times. The 6th version was right. I knew it was right the way you know things when you have been working on them long enough, not with excitement, but with the specific quiet of a solution arriving. I brought it to Teresa the following week. She tasted it. She was quiet for a moment. Then she said, "Where did this come from?" I said, "It came from me." She said, "Put it on the Tuesday menu." It sold out. She put it on the permanent menu. It stayed there for 2 years, which is a long time for a menu item, and every plate of it that went out of that kitchen was mine, my thinking, my ratio, my solution to the problem I had been carrying in my head. The burden of proof was on us. The notes were the proof. I sat with this for several evenings. Not anxiously. I had processed the anxiety in the first week after the kitchen table meeting, and what I had arrived at was the specific stillness I recognized from the moments in my career when I understand what the document says and what it means. Stillness because the thing is real and knowable and I know it. I read through the notes in order. All 23 months. I read them the way I would read a deposition transcript, looking for the substance and the gaps. The substance was good. The record was clear and detailed and dated. The gaps were few but noted. There were 2 dinners in year 1 where significant things had been said, and I had not made notes until the following morning, past my 4-hour rule. I flagged those to Constance as reconstructions rather than contemporaneous records. Constance said, "Most attorneys would kill for this kind of preparation." I said, "I have been making these kinds of notes for other people's cases for 22 years. She said, "How does it feel to make them for your own?" I thought about it. I said, "Like the job makes sense in a way it didn't before." She looked at me. She said, "What do you mean?" I said, "I have spent 22 years watching people come through the door without the documents they needed. I always thought, if they had just kept the records. And then I watched myself almost do the same thing, because the room was warm and the people in it were family, and I let the warmth override what I know." Constance was quiet for a moment. Then, "But you didn't do the same thing." I said, "Not fully. The notes are what I had instead of the agreement I should have drafted." She said, "The notes are what most people don't have at all." I said, "I know. That's what this story is about." She looked at me. She said, "You're going to tell people this, aren't you?" I said, "Yes." She said, "Good. I want to tell you about Mitchell." Mitchell Weatherly is 46, works in software, has lived in Denver for 11 years, and has the specific quality of people who are not often in the room and therefore have strong opinions about what should happen in the room. He is not malicious. He is distant in every sense of the word, and distance from a situation allows you to have the cleaner version of your preferences, uncontaminated by the texture of what actually happened. He had not been in the house when Dale and I moved in. He had not been there for the 2 years of dinners and maintenance schedules and appointment driving and early mornings in the garden. He had been in Denver, making his own financial plans with his own reference points, and the reference point he had for Dale and Simone was the one Carla had given him, which was colored by what Carla preferred to be true. At the conference room meeting, when Eleanor said I meant it when I said it, Mitchell was silent on the phone for a long moment. Then he said, "I didn't know all of this had been documented." Constance said, "It has been documented since month 1. Another silence. Then Mitchell said something that I did not expect. "What do you need from me to make this work?" Constance looked at me. I said, "Your signature on the agreement and your honest answer to one question." He said, "What question?" I said, "The email you sent 14 months ago, where you asked if Dale and I planned to stay long-term because it affected your financial planning. Did you understand, when you wrote that email, that our staying long-term was connected to a larger share of the estate?" A long pause. He said, "Yes." I said, "Thank you." He signed the agreement 3 weeks later. He was the first signature after Eleanor. Mitchell is not my favorite person. He will never be my favorite person. But he is a person who, when given the accurate version of events and asked directly, chose accuracy over the version that cost him less. That is worth something. I have worked with enough legal disputes to know it is not always what happens. The conference room was a Wednesday in October. I had been in that building hundreds of times over my career, for other people's matters, in the specific background role of the person who has prepared the file. I had handed attorneys their documents, organized their exhibits, anticipated their needs. On Wednesday in October I sat at the table, not in the background. I was the client. I had prepared my own file. I knew every document in it and what it established and how it connected to the others, and I had organized it the way I organized every file I had ever managed, by date, cross-referenced, indexed on a cover sheet. Constance had looked at the index page and said, "Did you do this yourself?" I said, "I do this for a living." She said, "Do it for a living on this side of the table too." I thought about that. I said, "Maybe someday." She said, "You have the instincts for it." I did not become an attorney that afternoon. I am still a legal secretary, still on the other side of the table in the professional sense, still the person who prepares the file rather than argues from it. But something shifted that day in how I understood the relationship between my work and my life. I had spent 22 years acquiring knowledge about how things work, and I had spent 49 years being slightly apologetic about using it in my personal life, because using it felt like distrust, and distrust felt like disloyalty, and disloyalty in a warm room felt like a kind of violence. It is not. I know that now. Not through argument, through experience. Through 3 emails and 23 months of notes and a conference room in October and an attorney who said you have the instincts for it. I have always had the instincts. I was just waiting for permission to use them. This is the permission. Use them. One more thing before I let you go. I went back to Hyde Park last month. Not for any particular reason. I was driving through the neighborhood and I turned down the old street without deciding to, the way you turn down roads that were yours once. The house has been repainted. A different color. A dark green that I would not have chosen, but that works, actually, against the white trim. The garden is different too. The new owners have done their own version of it, which is their right, and which is theirs now. I sat in the car for a moment. I did not go to the door. I was not looking for the house. I know where the house is. It is where it has always been. I drove past it. I was looking for the feeling of it, the specific quality of what it had been, and I found that I could hold it clearly and without grief. This surprised me. I had expected more grief. What I found instead was, I built that. I know what I built. I know the garden I planted, and the deck, and the 9 years of evenings. I know it because I was there and I remember it and, yes, because I am the kind of person who wrote it down, who kept the grocery receipts and the renovation invoices and the notes from the conversations that mattered. I know what I built there. I also know what I am building in Anderson Township, and I know what it means, and I have the agreement that says what it is worth. I pulled away from the curb. I drove home, which is the Colonial now, which has Eleanor in it, and the garden in its 2nd year, and the office I painted myself in September. I pulled into the driveway. Dale was in the kitchen. Eleanor was on the back porch. I went inside. I made tea. I sat at the table where the family meeting had been, the kitchen table in the house that is not mine in the same way the Hyde Park house was mine, and that is mine in ways the Hyde Park house never was. Both things are true. I hold both. The record knows. There is something I have not told you yet about the 3 emails, and I think it matters. The day I discovered them, not discovered, I had written them myself or received them, I had always known they existed. The day I went back and read them with the intention of using them, I sat with each one for a long time. Not reading the legal content. Reading the human content. The version of the situation that each email contained. Eleanor's email, the one about our sacrifice, she had written it on a Sunday evening in the 1st month. I remembered that evening. We had all had dinner together, the first real dinner since the move, and it had been good, easy and warm and not yet encumbered by the complications that come later. She had written the email that night, I think, because she had felt something and wanted to put it somewhere before it became ordinary. She had been grateful in a way that needed expression. I had saved it because it was an email about our living arrangement from a party to the arrangement. I had not been strategic about it. I had saved it the way I saved everything relevant, because saving things is what I do. Reading it 2 years later, looking for the legal language in it, I felt something adjacent to sorrow. Not for myself, for the version of that Sunday evening that the email represented. Eleanor, grateful and saying so. The arrangement, new and full of goodwill. Me, saving the email in a folder without knowing why yet. That version of Sunday evening still happened. It was real. The email is its record. The conference room does not retroactively make it false. I think this is important to say, because I do not want the story I am telling to be a story about cynicism. About going into every warm room with your defenses already up, your folder already open, your legal language already loaded. That is not what I am recommending. What I am recommending is that the warmth and the documentation can coexist. That you can be present at Sunday dinner and also send yourself an email afterward. That you can love the people in the room and also keep the notes. That these are not opposing acts, they are complementary ones, because the documentation is what allows the warmth to remain the warmth when the dispute arrives. Without it, the warmth becomes contested. With it, the warmth is on the record, and the record says, "We were here, we were good, we meant what we said." Eleanor meant what she said in that first-month email. The conference room confirmed it. The agreement now formally reflects it. The Sunday evening is still the Sunday evening. It is just also evidence. I have been a legal secretary for 22 years, and in those 22 years I have seen many people come through the door. People who have been wronged and have proof. People who have been wronged and have none. People who think they have been wronged and have proof that shows otherwise. And people, this is the category I want to talk about, people who have been wronged but who did not know at the time that they were building the documentation of it. These are the people who kept emails for no particular reason, who wrote notes in their planners that they never referred to again, who took a photograph of a document on their phone because something in them said, "Keep this," who forwarded a text to themselves at midnight because the text said something they wanted to remember. These people did not know they were building a case. They were doing what careful people do, preserving the record of what was real because the record of what was real seemed worth having. When they come through the door and they find out that the thing they were preserving without a plan is the exact thing the attorney needs, that is the moment I have seen more times than I can count. The relief of it. Not triumph. Relief. I want to be the thing that makes you do it before you need it. Not the person who tells you what to do after the fact. The voice in your head, when you get home from the Sunday dinner, that says, "Write it down. Just in case." Just because it's real and real things deserve a record. It takes 5 minutes. It takes one email to yourself with the date in the subject line and 3 sentences describing what was said and by whom. It takes the discipline to do this even when you do not expect to need it, especially when you do not expect to need it, because the unexpected arrival of the need is the only kind that matters. I am 51 years old. I have 22 years of other people's cases behind me, and 1 case of my own, and a conference room in October where I was the most prepared person at the table. I was prepared because I had started 2 years before I needed to be. Start now. Whatever the arrangement is, whatever the room is, whatever has been agreed and not yet written, start now. Date it. Send it to yourself. Build the folder before you know what the folder is for. You might not need it. I hope you do not need it. But if you do need it, you will have it, and having it will be the difference between a claim and a feeling, and only one of those works in a conference room. Keep the record. Trust the room. Know the difference between those 2 things. Go plant something. Write it down when you do. There is a woman at my firm named Loretta. She has been a legal secretary for 31 years, 9 more than me. She sits 2 desks away and has the calm of someone who has processed enough human chaos to have become essentially unshockable. Loretta knows where every file is. Loretta can reconstruct a timeline from a disorganized email chain in 20 minutes. Loretta has been married to the same man for 38 years and has 3 children and 6 grandchildren and does not take nonsense from anyone. I told Loretta about the situation in the week before the conference room. Not because I needed her advice, I had Constance for that. Because I needed someone who understood the specific texture of this kind of thing and would not offer me a simplified version of how to feel about it. Loretta listened the whole way through. She did not interrupt. When I finished, she said, "How long have you been keeping notes?" I said, 23 months. She said, "That's about right." I said, "What do you mean?" She said, "You start too early and it looks like you anticipated a problem. You start too late and you don't have enough. 23 months from the beginning, that's about right." I said, "I wasn't timing it." She said, "No. But you started when you should have, which means your instincts are good." I thought about that. I said, "Did you ever have to use yours?" Loretta looked at me over the top of her reading glasses. She said, "What do you think?" I waited. She said, "Property dispute. My husband's family, 15 years ago. His sister wanted a cabin that had been verbally promised to us when his parents died. We had 2 letters and a recorded phone call I had made myself because I had a feeling." I said, "A recorded phone call?" She said, "His parents knew I was recording. I told them I liked to keep records of important conversations and they said fine. They were lovely people. The point is, I had it." I said, "What happened?" She said, "His sister backed down when she saw the letters and found out about the recording. We got the cabin. We sold it 5 years later because it needed a new roof and neither of us wanted to deal with a cabin." I laughed. She did not. She said, "The point is not the cabin. The point is she would have taken it. And I would not have had the documentation if I had not started keeping it a year before the problem appeared." I said, "How did you know to start?" She said, "Same way you knew. Something in the room felt like a future dispute. Not a certainty. A possibility. That's enough to start the file." We sat with that for a moment. Then she went back to her work and I went back to mine, and neither of us mentioned it again because that is the Loretta way. Say the useful thing once, clearly, and then return to the task. I have been working next to Loretta for 9 years. I have learned more from the way she manages her files than from any formal training I have had. Not the technique. I knew the technique. The philosophy. The understanding that documentation is not paranoia. It is respect for what is real. It is the insistence that what happened, happened, and that insistence requires paper. She keeps a cabin she does not have. I keep a house I have in a different way than I expected. We both keep our records. That is the end of the story. That is all of it. A woman who has spent 22 years making files for other people finally made one for herself, and it held, and the holding was enough. Keep your records. Trust the people in your rooms. Write it down when you get home. Go. Start tonight.